So hi there folks, Alex Woods, solicitor at Court Wingman. So what is a cause of action and why is it such an important concept for litigants in person to understand? Now we've had a bunch of cases just recently. We've had a partnership dispute between doctors, we've had a dispute between someone who bought a property and the developers. We've had quite a complex cohabitation property dispute to deal with. And those are all classic examples of cases, claims, where you really do need to get a little bit of an understanding of what specific cause of action it is that you're going to pursue in terms of bringing a claim in the courts of England and Wales. I like to think of a cause of action as, and you can buy this book, which we spent 2 years producing, and there's a whole section on it on pleading your claim, and before you do that, identifying the actual cause of action. A cause of action is similar really to a runway at an airport. Okay, just think of this, just bear with me whilst you consider this simple analogy. Now if you have got a large commercial airliner, you're going to need to, take instructions from the control tower, have got a detailed understanding probably of the civil aviation, that white book that all the pilots carry around in their briefcases. You're going to need to choose or be told which is the best runway to use. And if you fail to do all of these things, well, then you come a cropper. By contrast, if you have, a single prop Piper plane, which is the sort of plane that my father used to fly, actually, he was a pilot, and we used to just drive on a Sunday afternoon, those were the days, there wasn't much red tape then, to a farmer's field. He had a share in a small plane that was in basically a cow shed, a hangar, but a large cow shed, and we used to use the field. Now, look, most cases are going to be relatively straightforward, and you probably won't even need to understand the concept of what a cause of action is. Take for example a simple contract claim where you bought a black and white, you've bought a colour television, you get it home, it's black and white. Your claim form can be super simple. You wouldn't even need to attach an additional pleaded particulars of claim to the N1 claim form if it's a typical Part 7 county court claim. You're just going to say what I said, because a judge understands what cause of action, what runway, if you like, you're bringing your case, you're using to launch your case. It's contract, and every judge in the land understands the simple principles and the components of what it is to have to plead a cause of action in contract. Probably similar with slightly more complex but still pretty straightforward misrepresentation. Let's say you were induced into buying, a lawnmower. The contract itself just said, here is a lawnmower, gave the age, gave some details, maybe gave some paperwork, but the person selling it to you said, oh, it actually delivers a top speed of 50 miles an hour on a good day, and it's really zippy. And even at 50 miles an hour, it is not at all thirsty, and you'll only have to top it up once a month, even if you're mowing the lawn once a day. Now, you might go, oh, really? And that might then induce you into entering into the contract, even though what he's said, the representation, is not in the contract. So that wouldn't be a straightforward contract claim. That would be a claim under the Misrepresentation Act. Negligence, driving a lawnmower into your neighbour's greenhouse. You hardly need to get into the cause of action there. But again, it's the cause of action is negligence, the law of tort, the subsection of the law of tort. So you've got a lot of straightforward, simple runways, and for most low value, although it's not often it's simply a case of value, But for most claims going through the county court system, you don't need to worry about this video really, and you can just get by reading a book or using your Noodle or speaking to your cousin who's a law student. Now, however, there is a whole range of mid-claims, a sort of second category, and let's just say that's, I don't know, corporate jets that are small, but they still need permissions from the control tower, and they have to use a certain runway, let's say, but maybe they don't have to fly at a certain altitude. Well, those are perhaps your typically fast-track type claims, where there clearly is some level of complexity, but you can probably do it yourself. I guess a building dispute might fall into that category. A financial mis-selling claim might fall into that category. The notorious payment protection insurance scandal, for example. I handled a lot of those cases back in the day, and woe betide you if you just issued a claim in the county courts, even if it was only for a low value, without knowing what cause of action to deploy. You might, for example, need to understand that there's parliamentary legislation that's enacted, a statute under the Consumer Credit Act, as amended in 2006, called the Unfair Relationships Test. Now, a lot of your judges won't even know what that is, and certainly even if they do, they'll want it properly pleaded. In other words, they'll want you to communicate to the court that you understand and you've laid out the components that you need in order to make out a successful claim under the Unfair Relationships Test. Yeah. Now I just will read to you a section from the book, because this is a quote from a judgment that, a client that they approached in a bit of a pickle because they'd got a court order from the judge. They hadn't properly prepared their particulars of claim and identified the correct cause of action. And the court order said verbatim that he needs to file and serve a completely fresh amended claim. His opponent applied to strike out the claim, and there was a 2-hour hearing listed, fully complying with the Civil Procedure Rules 1998, and in particular identifying the questions which the claimant wishes the court to decide, or the remedy which the claimant is seeking, and the legal basis for the claim for their remedy. And if the claim is being made under an enactment, what that enactment is. If you do not correctly identify the appropriate cause of action in respect of your claim, if you do not, in other words, use the right runway, you risk either having your claim struck out, or more commonly having a judge order, particularly if you're a litigant in person, because he want to give you a proper chance to get it right, to amend your claim in a certain time frame. The kicker is that after that's happened, he will then make an order of costs against you, because the other side have basically wasted time and money on getting you in front of the court for the court to tell you that you've brought the claim in the wrong way and you need to go away and plead it correctly, draft the particulars of claim correctly, identifying the cause of action or the legal concept upon which your case is based and any enactment that is relevant. For example, I was in the habit of actually putting the statute in the front on the front page, on the first page of the M1 claim form, so that the court clearly knew what type of claim it was before then going on to plead the particulars on the second page or in a separate attached properly formatted particulars of claim. Costs order against you, paid within 14 days, £2,000. It might only be a £12,000 claim, and already you're on the back foot having to go away, and then you've got to spend more money on getting legal advice from court wingman or law firm or whoever, because you're now in a pickle. The clock is running, So it's far more intelligent to have properly prepared your case and identify the legal concept before you issue proceedings. Yeah. In this category of, let's say, semi-complex cases, such as a financial mis-selling case. I would also put personal injury into that category as well. We've got clients whom we help or have helped in the past with personal injury matters. We don't do a huge amount of personal injury, but we do it from time to time. And there are very specific rules governing the bringing of personal injury claims, particularly what you need to do before you issue proceedings, and also the values and what value a claim gets allocated to what track, da-di-da-di-da-da-da-da. So personal injury is also sort of a semi-complex category. But you could get away with it by using a support service. You might not have to formally instruct a law firm in order to run it. But then there is the final category of cases where really the cause of action is just too tricky for you to attempt yourself. I know you'll be thinking, well, shouldn't there be such a thing as access to justice, and whatever size or shape of the claim that I'm running or bringing, I should be allowed to do it on my own. Think of the famous McLibel case that I dropped into when I was a young law student at the Strand. It went on for months, and two litigants in person who had allegedly defamed McDonald's ran their own case, and it was almost as if the courtroom became a permanent office because it ran for so many months. Sure, the system does doff its cap to litigants in person, but it was a lot of time and a lot of money, and I bet they got quite a hefty costs order against them, even though they did in part make out some of their claims against McDonald's. Because it's just too complex, like defamation. Cohabitation, property disputes, too complex. The law is not black and white if you're not married about how to divide the property if you separate. Contested wills, too complex. Chancery division, caveats and warnings and, undue influence and all the rest of it. There's so many different variations on the cause of action that can be brought in a contested will case. Were they unduly influenced? Did they have lack of information? Did they have lack of mental capacity, lack of knowledge of what they were signing when they did their will? Is there a claim against the estate because a promise was made by the person who died years before, promissory or proprietary estoppel? These are all very subtle, complex causes of action that you really shouldn't attempt on your own. And I'm sorry, I love the idea of people running their own claims, and that's what Court Wingman is all about. But where complex, let's call it a category 3 claim is concerned, and it's a Boeing 747 or Dreamliner or whatever the latest is, and it needs a proper runway of a proper length and all sorts of controls and rules and regulations in place, then you do need not just a control tower, not even just a navigator, but you need a pilot. So I hope that gives you a flavour of what the cause of actions are. To conclude, a lot of people who use our service, whether through the sister law firm South Bank Legal or as a litigant in person, they have good cases, and they have a Spitfire. But the problem is, unfortunately, they take off the wrong way. They get to the battle zone, and they're ready to engage the Messerschmitt, their opponent. But unfortunately, they're told by the kind of, civil aviation referee of the skies, the god of the skies, because there are rules, I'm afraid, as far as this analogy is concerned, and he's saying to them, sorry, mate, you used the wrong runway, go back and start again and use the right one. Oh, and by the way, you've got to pay for all the time, the money, the maintenance, the petrol of the Messerschmitt, because he's got to go back home again and start all over again. It's a silly analogy, but it's exactly like that. It's just so annoying, isn't it? It's like, I'm here, I'm in my plane, it's a good plane, and you're telling me I've brought the claim the wrong way. So don't be surprised if you haven't brought a slightly complex claim properly, that you'll be penalised in costs, because that's the way the county court, high court, civil litigation works. It's the cost hammer, the cost bat that's used to beat you with if you make procedural errors. So just by way of wrapping up the analogy, if you like, the ammunition that you've loaded your claim with is the evidence, but that doesn't come to a much later stage in civil proceedings. You don't produce your witness statement, your evidence, till quite late on, just as you don't fire until you actually get in front of the enemy in the skies. Yeah. But you need to have had it loaded and know that it exists before you bring a claim. Likewise, I like the other important area is issues, which kind of related to causes of action. I may do another vlog on issues, or watch my series on Johnny Depp and Amber Heard, because what's so interesting about that for me is where the lawyers themselves have misunderstood what are the right issues. Issues is a bit like, being in the right sort of battle zone, like be able to come out of the sun. You've got to you're in the right position, because when your claim gets in front of the judge, as I alluded to in that order, which also refers to issues, you've got to position your claim properly by pleading it correctly, pleading the cause of action, i.e. it's a claim under the unfair relationships test, but you can't just explain the cause of action, the legal concept. You've all got to apply your facts to the legal concept, and that is when you get into properly pleading the issues. Those are the things that you want to put before the court for the court to make its decision on, and you want to be quite laser guided about that. So if it's an unfair relationships financial mis-selling PPI claim, it may be that the bank clerk got you to sign a PPI form that was added to your loan, and told you that if you didn't sign, you wouldn't get the loan. Now, that's unfairness, clearly, yeah, but you also need to explain to the court that the critical issue, the central issue that you want the court to adjudicate on is whether that happened, whether the bank clerk did actually make it obligatory that you take the PPI. And you'd actually also probably plead the principles that the bank has to comply with. Every area of life has got regulations, isn't it? And if you can demonstrate that the bank has broken its own regulators' rules, the Financial Conduct Authority's principles, you then say, and that's a breach of Principle 5, to treat customers fairly and not force them to take products that they don't want or make them a condition of a loan. Don't, and this is definitely one of the most common categories of client that we get calls from, be on the phone 7 days before a deadline and saying to us, I've got this court order and apparently I've brought the claim incorrectly, I've got to pay $2,000 and I've got 7 more days to file and serve an amended particulars of claim. Get that done, read the book, watch the videos, or get some legal advice, especially if it's a more complex claim, before you even issue the claim. Okay, that's all for today. Thanks, folks.